Good afternoon, everyone. My name is Murray Hunt, and I'm the Director of the Bingham Centre for the Rule of Law, on whose behalf I'm delighted to welcome you all to this afternoon's online event, at which the Director of Public Prosecutions, Max Hill QC, will be talking to us about prosecuting in the public interest, independence without isolation. Max has published a fascinating essay, which is available on our website on this subject, which has already sparked a lot of interest in the media. And today, we're very fortunate that BBC broadcaster Razia Iqbal, who will be familiar to you all, will be exploring some of the themes in Max's paper in conversation with him, and followed by a question and answer session in which you can all participate. Prosecutorial independence is absolutely vital to the rule of law and to maintaining trust, the public's trust and confidence in the criminal justice system, something we've all become even more aware of during the coronavirus pandemic. But it is coming under growing pressure in many parts of the world, where a number of governments are increasingly tempted to assert executive control over this very important part of the state machinery. The independence of the institutions on which the rule of law depends is also an increasingly important subject in our own country, as we've recently been reminded with the resignation in the last couple of weeks of the head of the government legal department, Jonathan Jones. And I'm very pleased to be able to announce, therefore, that this event today is the first in a series that the Bingham Centre will be holding, exploring the meaning of the important concept of independence in relation to various institutions on which the rule of law depends, and on which we depend to uphold the public's trust and confidence in those institutions. And we very much look forward to you all joining us in those events in future. So please watch this space. Enjoy today's event. Thank you all very much indeed for coming. Thank you to Razia. Thank you very much indeed in anticipation, Max, and over to you, Razia.
Murray, thank you very much indeed. Good afternoon, everyone. It's a real pleasure to be here and in conversation with Max Hill. He has been Director of Public Prosecutions since November 2018. At the time of his appointment, he said he was very aware of the challenging times the CPS was operating in, and that he was determined to build public trust in the work of the CPS. Today, we're here to discuss issues arising from his essay, Prosecuting in the Public Interest, Independence Without Isolation. He's going to talk for about 10 minutes. He and I are then going to speak for about 20, maybe 25 minutes, and then there will be opportunities to have questions from the audience. So do please get those ready. Given the even more challenging times that we are living through in 2020, there is an awful lot to talk about. So first, can I invite Max Hill to outline your concerns and what you have outlined in that essay as a starting point for our conversation. Max Hill.
Thank you very much, Razia, and thank you to Murray and to the Bingham Centre for hosting us. Welcome to everyone. Thank you very much for giving us time this afternoon. Let me start with something obvious. The coronavirus pandemic has changed many aspects of our lives beyond recognition. The circumstances in which the criminal justice system operates changed completely, really, in March this year. And so the way that the Crown Prosecution Service works shifted, dramatically shifted, in a very short space of time. When lockdown began, the CPS had to continue to operate, but do so within the restrictions imposed. And almost immediately, most of our colleagues left offices and courts across England and Wales and started to work from home. We actually went from around 500 people working remotely to 5,000 colleagues in the CPS working from home the day after lockdown was announced. Considerable investment, which needs to be ongoing, by the way, in our digital capability, meant that working remotely could become the norm for many, but I emphasize there were CPS staff who continued to appear in person, in court, throughout lockdown, as well as those who travelled to our offices to do vital work that could not be completed from home. And I do want to say how grateful I am to them all. We worked closely with colleagues in the judiciary and the courts to embrace rapid innovation. Example, there have now been more than 30,000 remote hearings by video link since the start of lockdown. And at the height of the pandemic, our advocates were regularly appearing in that way through a link. Technology was immensely helpful in enabling more court business than could have been accommodated physically, freeing up space for those hearings that did need to take place in person. We also prioritised the most urgent and serious cases, taking action to ensure public safety. Then, as restrictions relaxed and more hearings were able to take place, so too more of our colleagues have started returning to courts, and that number continues to rise. Throughout all of this, we've remained firmly rooted in our mission, which is to deliver fair and independent prosecutions. That underpins the rule of law and it protects the public interest, as Murray foreshadowed. During these extraordinary months, and they have been extraordinary, I've regularly had cause to reflect on what independence means for the CPS in 2020. Because our independence is vital, but alone it's not enough. And that has never been more evident than during the recent challenges I've mentioned. So the need to balance or to bolster independence with a broad and open approach to justice, which makes sure that the criminal justice system is here to serve all of us, has been at the forefront of my mind throughout the national crisis. So as we look to the future, we know that we need to be independent and I've got three things for you: collaborative, responsive, and adaptable. Collaborative, responsive, and adaptable. Each of those themes directed and defined our work in normal times, but they also underpin our coronavirus response. So just as independence is central to our function, our success as a prosecution service lies in the quality of the relationships that we have with our partners. So everything we do must be collaborative by design. Collaboration was essential to a compelling and cohesive criminal justice response to the pandemic. And we at the CPS were an integral part of the criminal justice system strategic command, which brought together all parts of the system, including advice from NHS and public health experts on health and safety considerations. And we worked together to identify and avoid potential issues and find practical solutions to the challenges we faced, and to maintain continuity of service for the public. We've also been responsive. Our independence cannot be an excuse for cutting ourselves off. We need to listen carefully to the communities we serve and to be open to changing our approach in response. We need to explain our decisions to those whose insight we seek, and even when those conversations are difficult or even uncomfortable. We, of course, do not make the law. That is a matter for Parliament. It's our role to work out how it's applied in each case in the service of justice. How do we do that? Well, we listen. And over the past few months, colleagues across the CPS have been thoughtful and creative in finding ways to continue communicating with local communities. We may be in extraordinary circumstances, but we've continued to prioritize listening to the public we serve, making sure we remain visible, and reassuring people that we are still here to help keep them safe and ensure that justice is done. Now, I thought I knew what it was to be an adaptable prosecution service before coronavirus. But the past few months have tested our ability to adapt to external forces beyond anything that we could have anticipated. We continue to review and adapt our operations, our working practices to respond to the impact of the pandemic and the range of ways in which our service will need to continue to change. So being all of these things, collaborative, responsive, and adaptable, that informs the service we provide and the public interest test that we apply. And so it supports our role, protecting the public and upholding the rule of law. When coronavirus meant that our communities faced uncertainty on all sides, we made it clear from the outset that crime would continue to be taken seriously and that our approach would consider types of offending that were specific to the current situation. So we completed more than 300 prosecutions for assaults on emergency workers during the first month of lockdown. These cowardly attacks, and that's what they are, usually involve frontline workers being coughed at or spat on by people claiming to have the virus. So we reassured the public early on that these crimes would be prioritized for charging decisions and that the coronavirus element would be captured by prosecutors and then treated as an aggravating feature in court. So where are we now? There's a feeling, I suggest, across society that we are at something of a turning point. Of course, we've lost a lot. Many of us have been bereaved. Isolation and disconnection have made this a lonely time for many. And in the criminal justice system, we are facing a significant backlog of cases. That presents the whole system with unprecedented challenges, and we will not return to anything near normal for a long time. But there are opportunities too, and I'm confident that the ways of working that served us during the early months of the pandemic will continue to serve us as we navigate through and ultimately into its aftermath. Our mission to deliver fair and independent prosecutions will continue to guide us. In the past 6 months, if we've learned anything, it is that the future is always uncertain. But what I can say is this: effective collaboration with our partners, a responsive mindset, and the ability to adapt will ensure that the CPS is fit to respond to the challenges ahead. And rather than threatening our independence, it's these traits that will help us to preserve it and to continue to deliver justice on behalf of the public that we serve. That's what I'd like to say in introduction. Razia, over to you.
Max, thank you very much. Let's start by, there's an awful lot to unpick in what you have said. Let's start with the kinds of assessments that are made in the public interest in cases during the pandemic. You mentioned the numbers of prosecutions, but there were cases that you had to review under the Coronavirus Act, and I think some 120 cases were found to have been incorrectly charged. Can you just give us some indication of what informed the decision-making process that led to that being the case?
Thank you. Yeah. So the first thing to say is that the code for Crown Prosecutors applies in every single case, whether that's a new COVID case or is an existing offence, or indeed a matter under common law. So we look at the evidence, we apply the evidential stage test and the public interest stage test. So that we need to put that in place first. That's the foundation. To answer your question, in dealing with the pandemic and the huge impact of the pandemic, we as a criminal justice system tried to put in a number of mitigations to help us to cope. That's before we come to new legislation, and therefore we at the CPS developed a charging guidance, an interim charging guidance, which was designed to make it very clear that certain types of crime had to be prioritized and brought into the system, but others perhaps could be brought in a slightly slower way because of the inevitable impact and the delays in the system. We also introduced public interest guidance, which is not new. I've just said it's part of our code. Every prosecutor has the public interest in mind when charging a case and is then bound. It's part of their responsibility to keep reviewing the public interest during the life of the proceedings. But we brought out some specific guidance on to remind people of how that is done. Then stage 3, we were dealing with new legislation. And I do want to say here that when the Coronavirus Act and the accompanying coronavirus regulations, and the latter keep changing, when that was brought in, that initially became a huge burden for police nationwide. And I do think we need to give a measure of understanding, a margin of appreciation, as lawyers sometimes say, to police officers nationwide trying to grapple with this very new law enacted by Parliament. In the specific example you give, it is right that when the police were charging, and it was for them to charge and not for us, I can expand on that later if you like, it became clear as those cases made their way into court and came into our orbit that perhaps not every decision had been made accurately. And so we did, between March and July, we actually reviewed, I think it was 659 prosecutions, so individual cases brought under the Act or under the regulations, and those brought under the Act, there were 121 of them, were found to be wrongly brought, wrongly charged by the police. Now, before everyone rushes to criticism, I would just say it was a very complex legislative framework. It was imposed by Parliament for all sorts of good reasons, more broadly than just criminal justice. But it did mean that when charging under the Act, it only applies as a specific offence under the Act where you are dealing with a potentially infected person. So that was geared, for example, at somebody who was disobeying instructions from doctors and nurses and leaving hospital when they were already infected, and they might be committing an offence under the Act, as opposed to somebody who was being violent, threatening or abusive in the street or in the supermarket or a car park, possibly claiming that they have the virus, but not themselves potentially affected person. So errors were made in charging under the Act when actually the regulations should have been used. Although, final thing I'd say, Razia, is in almost all of those cases, that wasn't the sole charge that was brought. In almost all cases, an individual was also charged with the assault on emergency or worker offence or a public order offence. So even though the Act charge was wrong, the case still survived, not in every case, but almost every case by virtue of other charges.
Okay, but everything that you're saying suggests that to not just a lay person, but even many in the audience are in the law profession, that this is a law that is potentially badly drafted if what you're talking about is 121 people who were wrongly charged under it.
Well, it led to some confusion. That's a different thing to saying badly drafted. And I'm not going to go there. And so time to introduce the legal concept of separation of powers, which almost all in the audience will know, and hence the title of this event. We do not make the law. I've been very clear throughout the pandemic that the responsibility, and it's a heavy one, for adding to the statute book sits with the legislature in Parliament. So it's for the government in conjunction with Parliament to say what the law is. We are operational, and it's for us to put it into effect together with partners such as the police.
Is there also an aspect of the role of the CPS to advise on operational implications? So if you are learning that a law is confusing or difficult and that the police are charging far more people than the law, in fact, in the way in which the law is interpreted, to what extent is it the role of the CPS to advise the government in your relationship with them?
Well, clearly we have good connections, good working relationships, and actually those relationships have been promoted during COVID. Because in a time of crisis, everybody comes together to work as effectively as they can. Where that leaves us in relation to the law is, I've already said we don't make it, we don't change it either. We do point out the operational consequences when a law is brought into force. And an example already given is where you've got COVID Act cases which were incorrectly charged, we did then come in and say, well, can we help? Let's conduct a review and let's ensure whether this is at the police end of the spectrum or the CPS end of the spectrum, there's a proper supervisory process in place, there's proper triaging, and we do everything we can to make sure that when a case does reach court, it has been correctly charged. And I think that review we conducted when we were all under lockdown has been effective and has borne down on that level of confusion about the legislation.
So in the context of the Coronavirus Act and the regulations, who is it who makes the charging decisions? Because what you're saying is that the police had incorrectly charged this 121 people. In what context would the CPS make those charging decisions?
The answer is that prosecutions under the Act and the regulation are made, those charging decisions are made by the police. It's commonly thought that the Crown Prosecution Service charges every criminal offence. Actually, we don't. We prosecute them when they come to court, doesn't mean we charge. And that's for sensible reasons. In decades gone by, the police almost had a prosecutorial function. When there wasn't a Crown Prosecution Service, the police would regularly charge and then present cases in court. Everyone remembers the police courts. Now, for what I'm hesitant to call volume crime, but you know what I mean, very, very high number, in many respects, not the most serious offending, it is still the case that the police will make the charging decision without recourse to the CPS. When it then comes to court, we take it over and we prosecute it, and we need to review it. That's in contrast with the almost all serious crime in which, although it remains for the police to investigate, we come in at an earlier stage, we advise the police on the legal elements, and then we make the charging decision. So you do have this split, and I'm not arguing to alter that, between very high volume, low seriousness offending, which the police can and do charge, and then equally high volume, high serious offending, where it is for us to charge, even though in neither category do we investigate.
Let's talk about how the CPS worked with the courts, or is continuing to work with the courts in the context of the pandemic. Let's stay with that, but also go back a little bit to the delays that already existed in the way in which the courts were functioning in the criminal justice system pre the lockdown. There was a backlog in Crown courts in England and Wales of 37,000 cases or thereabouts. Now it's 46,000 cases. And so there clearly is a big issue that I'd like you to address pre-lockdown, but also how it's being dealt with in the context of the pandemic with those extra challenges and pressures.
Yes. Under normal running, I'm sure everyone can recognise you have to have a waiting list. There are bound to be cases that are coming through the system. Now, we call that backlog. In a strict sense, it is, but it just means those cases that are being processed through charging through the early stages. Every Crown Court case starts in a magistrate's court and is then transferred or committed through to the Crown Court. You are always going to have a substantial list of cases coming through. In fact, it was, to give total numbers from Crown Prosecution Service statistics, the number of live cases on what we call our case management system as at February, so pre-COVID, was 101,000. So that includes the 37,000 in the Crown Court and then adds cases currently in the Magistrates Court, so 101,000. So that's an ordinary backlog. Now, there will be those, I'm sure, listening who would say that's too high a backlog. From our perspective at the CPS, I would say to you, we would wish, put COVID to one side, that could be reduced because what comes with any backlog is the necessity for the participants in cases to wait. And that can be very corrosive, particularly where you've got a vulnerable victim of an appalling crime. Rape is always the headline example, but there are so many other examples. Domestic abuse, coercion and control cases, anything involving a vulnerable person who is made to wait before they can tell their truth in court. we should all be working together to try and reduce that to a minimum. But the fact is, it was 101,000 pre-lockdown. By the beginning of this month, that had risen to 179, just rising to 180,000. So there is a rise in the total backlog of around 75%. Now, that's inevitable when the courts, try as they might, were simply unable to operate as normal when we were all locked down and living at home. Although I would suggest that a comparative analysis of criminal justice systems around the world, when all this is said and done, will show that in England and Wales, in our legal jurisdiction, we stood back up much more quickly than many others. And that's partly a function of our sophistication being a digital service. But that's a lot to deal with, 180,000. And as I've said before, that's not something you can get rid of in weeks. It is something that is going to continue in the system for a considerable period of time. Now, I can go on to talk about the mitigations that have been put in place to try to reduce numbers, if you wish. But I'll let you ask a more targeted question.
Well, let me just pick up on where you think, you know, outside of the context of the pandemic, which is clearly added to the backlog. I wonder if you would reflect for us on another or many other reasons for the delays, because it's quite clear that there have been huge cuts to the police, there have been cuts to the CPS, and there've also been cuts to other agencies such as the probation services. And no doubt that informs the kind of backlog that we're talking about. I mean, the BBC report this week showed that some court centres are listing trials for 2023.
Yes, I mean, on that latter point, I think that's a specific COVID impact as opposed to a system under normal running. If we are seeing these very long hearing dates, that is because of where we are now, immediately post-lockdown. But as we know, government is doing a number of things, a range of things to try to increase capacity. So we are seeing Nightingale courts, so-called. We are seeing a little more.
I think how many, so let's just to interrupt you on the Nightingale courts, there are, my understanding, only 3 currently, is that right?
I think that number is rapidly rising. I think it's arriving in double figures, but those Nightingale courts are not all sitting in a criminal jurisdiction. Some of them are hearing tribunal cases, so civil cases, nothing to do with us. So there is clearly an issue over trying to increase capacity. That takes me to remote hearings. And as I mentioned at the start, the fact that we've been able to conduct 30,000 hearings remotely, that I believe is part of the answer and should be part of the answer long term. To coin a phrase, if I may, from the Lord Chief Justice in his Mansion House address on the 27th of July, gone are the days, he said, and I agree with him, when an advocate, it could be solicitor or barrister, could be CPS or external, will travel an hour or 2 to court, make a short application, and then travel an hour or 2 back from court. That's what was happening pre-lockdown. There were none of these remote hearings. We've now seen the technology, and this is partnership working. It's not just the CPS. And I think that we need to grasp that and bed that into the system. If you like, the new normal should include looking at every occasion when we can properly, and in the interests of justice, and that includes open justice, conduct hearings across a screen as we are today. That will drive down on backlog. It's not a sole solution, but it will help to drive it down.
But just to pick up on the original question, Max, the delays are also down to, even if you look at the 2023 listing for some court cases, are a direct result of the pandemic and the challenges that has posed, that there is an issue. And I wonder how you as the DPP navigate that with government that's to do with cuts. And that clearly is informing the delays too.
Yeah, let me be clear. I don't shy away from the challenges that I inherited and which we continue to face together at the CPS. We have a challenge in respect of efficiency and timeliness when it comes to disclosure. We have a number of other challenges in specific casework areas, and rape and serious sexual offences is another. And I do not shy away from that, and of course we'll talk or take questions on that later. So that is a fact. But coming to resource, as you've mentioned it, clearly I inherited a service which was over 40% down in real terms financially during the course of this decade. We just finished a decade. So about 44, 45% down in real terms financially, over 30% down in terms of headcount. So I was inheriting a seriously depleted organization. And that's why I did spend my first 9 months as we went through Spending Review 2019 with my teams here, and it's a testament to them, not to me, trying to impress on government that that decline had to stop. And I'm delighted that it did stop, and delighted that the Prime Minister in actually very early days of his office in July last year did say there will be an additional £85 million for Crown Prosecution Service. A lot of that is ring-fenced to allow us to continue our work on disclosure, which I just mentioned. A lot of it is ring-fenced to try to improve our headcount so we have more prosecutors, because we know there are at least 20,000 more police officers coming on stream. And that is going to generate an increase in the case number. Where we are now, going into Spending Review 2020, what I'm saying is, don't stop there. We need to continue this inward injection. Resources do make a difference, and I want to see that continue to rise. I'll be forgiven, I hope, for not going into the precise detail of what we're asking for from the Treasury. This is a matter for government, but I can assure you that our argument, our contention is that to allow the CPS to build back up, even pre-COVID, requires resource, and that is certainly true post-COVID for a whole host of reasons, including digital capability, which can reap real rewards, hence the remote hearings, and ultimately will deliver savings in efficiency. And that's our offer, as it were, to government, that you give us more spend now, we will save in the long term, but we've got to get over the backlog as quickly as we can.
So the 30,000 remote hearings that you were talking about, just outline for us the ones that can't be, the ones that the jury-led cases, and how that will work in terms of the context of the pandemic, which is not going to go away anytime soon. So the things and the systems that have been put in place to make it possible for jury trials to be made more efficient and to try and catch up on the backlog there?
I need to say at the outset that we don't control when and how a case is listed. That is a matter for the judiciary, and for every judge in his or her court, an individual decision is made as to what is in the interest of justice, and there can be no interference with that. What has happened, though, is that there has been a recognition in so many cases, I say 30,000 of them, that there are aspects of the process that you can conduct efficiently and effectively online, and you don't need people physically coming in. To answer your question, what does that leave? Well, undoubtedly it leaves the expression of guilt or innocence, the outcome of this great venture that involves so many participants in a criminal trial, and the delivery of fair, open justice in a court where all are present really mandates the physical appearance of all participants at trial hearings. And there are other sorts of hearings where it's almost inevitably going to be necessary for people to be physically present. But what I have seen, and I absolutely encourage, is a recognition that nonetheless it is in the interests of justice at other types of hearings. So what do I mean by that? I mean what we would call generally case management hearings. They're called plea and trial preparation hearings in the Crown Court, pre-trial hearings, effectively triaging the case in the Magistrates' Court. And when I referred to charging guidance and public interest guidance earlier, that's because what was put in place, and this is courtesy of the judiciary, who, as I say, remain in control as they must be, was a process of triage, particularly in the Magistrates' Court. So district judges and even lay benches who would previously, under a protocol we call transforming summary justice and better case management, they would automatically list a trial for a date a few months hence after the first hearing had taken place. Clear problem with that under lockdown. How can you be sure that all the participants can be there? So a triage system was put in place, and that had a number of effects It meant that we'd have much more certainty that when a case was listed for trial, it was going to be a trial. And that's effective use of court time, rather than setting aside a day to find that an individual pleads guilty at 10:30 and the rest of the day is clear. But also it revealed months before trial that actually there might be a way through this case. What we call an acceptable plea might be offered by the defendant, even though that wasn't apparent at the police interview stage or at the charging stage. So that's what our public interest guidance is there to govern, although, and I won't go on now, but I'm happy to take questions on it, I need to be very clear that where we gave guidance on the public interest, that was absolutely not the CPS going soft on crime or not bothering to prosecute. And one of the purposes of issuing that public interest guidance, as I made clear to the Justice Select Committee when I gave evidence to them in May, was to imbue our prosecutors with a sense of confidence that, take a simple example, where you're charging a serious assault, which is grievous bodily harm, even where an individual might be prepared under COVID to plead to a lesser offence, nonetheless, there is a public interest in putting that person on trial for grievous bodily harm. And unless they plead to that, it will go through to trial.
I'm going to throw it open to questions in a moment, but just before I do, Murray mentioned the resignation of Jonathan Jones in the light of the introduction of the Internal Market Bill. I wonder if you would be willing to share your reflections on the optics of this in the context of public trust, because when you have criticism of a government for breaching international law, including criticism from the European Union, it does follow to a layperson that it's much harder to persuade ordinary citizens to follow the rule of law if what you have is a barrage of criticism against a government breaching international law.
Yes. Well, let me say, so far as Jonathan is concerned, he was a colleague for almost 2 years, and I am very sorry to see him go. And in civil service terms, to come on board as I did as a new permanent secretary, having experienced people, fellow lawyers around the table, such as Jonathan, was a pleasure, and I'm very sorry to see him go. Beyond that, I have to stay within remit. I wouldn't be here this afternoon if I wasn't saying the rule of law is paramount, and that is the expression of principle. But remit, for me, means the domestic jurisdiction within England and Wales, understanding the laws that Parliament enacts and adhering to all of those laws is paramount, and that is essentially what I superintend in my way within the CPS within England and Wales. International law, international treaties, the Internal Markets Bill, I'm afraid these are simply not for me. They're not for me because enactment of any law or treaty is a matter for politicians in Parliament and not for officials like me. And they're not for me because it's got nothing to do with my jurisdiction. And on that basis, I'm afraid I simply can't enter into that territory.
Okay, so let's just for a final thought in the context of the pandemic, the whole issue surrounding Dominic Cummings and what he did under lockdown. Again, it's an issue of optics, right? If you've got people watching what a senior figure inside the administration is doing, and they are being told they have to behave in a particular way. As the Director of Public Prosecutions, how do you navigate that terrain? Because it's clearly problematic and it clearly falls within the framework of how you build public trust in institutions and the law.
Yes, I recognise the concern. How could I say anything other than that? But this is a matter of process. As I'd already indicated, when you're dealing with the COVID regulations, it's a matter for the police to investigate and to determine charge. And in respect of the case you mentioned, it was Durham Police who had it within their jurisdiction. They did not refer to us, nor was there any suggestion that they should have done. They looked at all of the evidence which is known to them, and they reached a final decision. The CPS was not asked, nor did we advise, nor was it our responsibility to charge in that case. So I suppose what I'm saying is, once you understand the process, it's up to everybody to say whether they trust the decision maker. And the decision maker here was Durham Police, who said at the time that they looked at this, they looked at all of the evidence, and they made a reasoned decision not to charge. It's not for me to say whether that's right or wrong, but I would place my trust in Durham Police or any of the other 43 police forces around this country, just as I would hope when it does come to us, and you are looking at cases which we charge, trust can be placed in us, and as to which we are transparent in the sense that we say how we make these decisions. And actually, we're increasing that. And in recent cases where it has been down to us to make the final decision, I encourage the fact that we are articulating, I think, more clearly and in greater length why we have reached a decision not to charge where that's the case. It all references back to our code, whether the evidential stage is met or not, whether there is a public interest in that case according to the factors in the code that mandates charge. So being transparent and explaining the process is very important, and we hope that by doing that there can be trust vested in the decision maker.
Thank you, Max. Let's open up the questions to the audience. I'm going to start with one from John Binns. Is there a greater role that can be played by the private sector in the form of private prosecutions and or private firms assisting with aspects of state prosecution? And the example that's given is confiscation.
Yes, well, I think there's a guiding principle here, which is that for a very long time now, it has been accepted by all that anyone can actually be a prosecutor. And so we do have private prosecutions. They are niche, they are small in number, but they exist. And I am not one to say that we should throw that rule away. There's a principle behind it, which long predates the Crown Prosecution Service. However, as to doing so in any volume, or as to taking over part of the remit of the public authority, which is now the Crown Prosecution Service, I have to say I do not see a role. And the reason I don't is because actually the Crown Prosecution Service is a very efficient nationwide authority. We provide extremely good value for money. The private sector provide value in a different way according to market considerations, according to who pays. And I would suggest that we are more efficient with the public purse. And that's why that work should stay with us. So the answer is not to hive off sections of the prosecutorial function and give it to others, still less to an unregulated sector. The answer is to maintain your focus on the public authority, to resource it appropriately, to require it to be efficient, to hold it to account, but to keep the jurisdiction together rather than splitting it up in any way.
Let's move on to a question from Harold Emanuel. This is an issue that is completely in the public domain, the drastic fall in the volume of rape case prosecutions. Given the common nature and the seriousness of the crime, isn't there a real danger of encouraging cynicism in the CPS and the rule of law when the message to offenders and victims alike is that rape has a low likelihood of being prosecuted?
Yes, thank you. Well, thanks for the question. I wouldn't have anything to do with cynicism if I found it at any level of the Crown Prosecution Service, whether dealing with rape crime or any other form of crime. And given that your question's directed towards rape and what we call our RASO teams, that's rape and serious sexual offences, I can tell you, because I've done this for myself, that if you go and spend time in the company with our dedicated and experienced prosecutors, particularly in relation to those pernicious crimes, and rape is one of the most serious in the book, you will not find cynicism. You will not find any lackadaisical conduct. You will find real energy, commitment, and a drive to get it right. You might find a little frustration that that isn't translated more generally and more publicly, and there isn't an understanding that these dedicated public servants exist to prosecute. They exist to bring cases. They do everything they can to improve the situation rather than to worsen it. But I guess that's partly my function, to try to articulate what they do and to do that more effectively. But I can assure you that there is no cynicism. It is hard work but they're absolutely dedicated to it. And I could go on about good examples of how that's done, but I won't unless you want me to.
There are a huge number of other questions coming through, but I just want to pick up on the issue of rape and convictions. I mean, there are campaigners, and you will know this very well, Max, that say that the CPS has actually changed its approach to rape cases, arguing that the service has scrapped the so-called weak cases to improve conviction rates. Yes.
And that has been a matter of contention for all of my time here, and indeed it predated me. The charge is that in some way the Crown Prosecution Service has moved to what some people call a bookmaker's approach. In other words, we won't make this decision based on the evidence or the public interest. We'll make this decision based on a guess as to whether a jury will like this complainant or this victim or not. I completely reject that. And indeed, when that challenge was taken, and I don't complain about the challenge, and let me say very clearly, as far as end violence against women, the Campaign for Women's Justice, they do a fine job, as they should, to articulate on behalf of their constituency, the victims of sexual violence. When they took that charge to the High Court, even though those proceedings are ongoing, the High Court, in a judgment in March, actually just as we went into lockdown, said that that allegation that we have fundamentally changed and we're adopting a bookmaker's approach was unarguable. And even though those judicial review proceedings are continuing, and I'm not going to go into the detail, and even though there are process elements that are yet to be determined by the High Court, that charge is utterly unfounded. And from my experience coming in and sitting with our prosecutors, I haven't found evidence that they do anything other than apply the code. And indeed, don't take it from me, our external inspectorate found in their report at the end of last year that there was 98% code compliant decision making.
Okay, I want to move swiftly on. We've got about 10 minutes and I want to get as many questions in as possible. This is from Rebecca Camber, Chief Crime Correspondent of the Daily Mail. What impact has the pandemic had on charging rates? Have the number of offences being charged fallen due to the pressure not to clog up the courts? And what's happening to those cases? Are those suspects just being released under investigation for longer, or are more cases being settled outside court via caution or community resolution?
Rebecca, thank you for your question. We know each other. I can't give you immediately a statistical analysis there, an answer by virtue of numbers. What I can say is that our interim charging protocol is the key document there. And Rebecca, you know about it, I'm sure. That says that we categorized into immediate or high priority or other 3 categories of cases on receipt from the police. And we loaded into those immediate and high priority categories what I hope you would expect us to load. Namely, to give an example, offences against emergency workers, those COVID coughing and spitting cases, domestic abuse thematically, and a whole raft of sexual and other violent offending, where you would expect us, whatever the crisis may be, to say, if the police give us sufficient evidence to satisfy our test, that will be charged. That case will be brought into the system. There will be no delay. And that is what we have done. There are cases, though, and I'm not going to give specifics here, perhaps, I hope for obvious reasons, where we can have a conversation with the police and we can reach an understanding of whether it is necessary to bring certain types of cases into the diary, the catalogue of cases before the criminal court right away, or whether actually that can wait without any harm being done. I emphasise that's not going to apply in cases of serious harm, violence, sexual or otherwise, or a whole raft of other cases. But sometimes investigations do take a long time and you don't have to charge it at the first time of asking. You can have a continuing conversation. So that has happened, together with a process of looking at whether there are acceptable pleas. I mentioned this earlier, so won't dwell on it now. And the way that works under our public interest guidance is if a prosecutor is presented with an offer of a plea to, let's say, to 1 charge on a sheet that contains 3 charges, if that prosecutor is satisfied that a plea to that charge would reflect the criminality and will put the judge in a position to pass an effective sentence, or in a custody case, applying the Sentencing Council guidelines would mean that even if one went on to trial, it's highly unlikely that the individual will receive any longer sentence than they've already served. Well, in combination, those might be reasons for saying we will take a plea here, and therefore we can take that out of the backlog. But the reverse of that, as I've already said, is where, regardless of what the offer may be, there is a case to take through to trial, an offence of serious violence. It doesn't matter whether you're offering to plead to something less than that, you are going through to trial. And the only way out of it is to plead guilty to the headline offence. And our prosecutors are confident in using that guidance. So that's what I'd say thematically. In terms of statistics, you have a backlog. I think we have borne down on it. Let me just add this. The backlog was rising very sharply, understandably, in the early months of lockdown. There are aspects that are still rising. The business that's going through from the Magistrates' Court to the Crown Court, in some respects, is still rising. But there are aspects that are levelling out, if not falling, and that particularly around volume crime in the Magistrates' Court. So we have put in some mitigations which have helped to reduce overall volumes, even though we are still left with that rump of a large backlog, which we've all got to address together. That's police, court service, judiciary, and the CPS.
Let's stay with the issue of the backlog. This is a question from the Home Affairs correspondent at the Press Association, Flora Thompson. Given what you've said about addressing the backlog, are you worried that the judicial process is being compromised and that defendants are being penalised because defence counsel are currently only having a maximum of 2-hour-long video conferencing slots with their clients each month?
Well, thanks, Flora, for the question. I mean, you're raising two fundamental principles there. One is the right to representation, and in the criminal jurisdiction, as you know, that is by and large free representation through the legal aid system. And I absolutely uphold that. So I can't deal with the minutiae of whether in an individual case, a defence advocate may say, I need a bit more time with my client, or I'm frustrated by the technology. But they are articulate, they're able to argue that. They make those submissions to the court, and any prosecutor would be saying, well, you know, if you need more time, then let me know. You know, it's a matter for a judicial decision, but you need to be ready before we argue this case. Second thing is, as far as the judiciary is concerned, I don't see anything that's happened over the last 6 or 7 months that's compromised the judiciary. On the contrary, as I've already indicated, the judiciary are firmly in control of when cases are listed. They are, I'm glad to say, using the technology to permit remote hearings, and I hope that will continue, but they're firmly in the driving seat, and it's the fundamental principle of each and every criminal case, wherever it is, that in our adversarial system, we both fight our corner, prosecuting and defending, but it is the judge who's in control, and I haven't seen that being borne down on or compromised.
So there are a few questions on the issue of the custody time limit, Max. So
Yeah.
I'm just going to outline the kind of broad brush strokes of the question. So one of them is your view on defendants, legally innocent people being held in custody awaiting trials for longer because of, in the view of this questioner, the government's failure to properly resource the courts and the justice system so that trials can be heard.
There is always going to be custody time pending trial, unless and until you had a system that permitted us to go from charge to trial in a single day. And realistically, there's no jurisdiction in the world that does that. So it's a question of degree rather than the absolute here. There are going to be people who we will submit to the court, and it's for a judicial decision, should not be allowed bail, should not be permitted bail, but should be held in custody pending trial. Obviously, it's in our interest, just as much as a defence interest, for that period to be as short as possible. And that is why the system remains under pressure to bring these cases through as fast as they can. We know that the government, and it is for government and not for us, are looking at a short-term, if you like, emergency provision to extend the initial period of pre-trial custody from 156 days, which it has been for a long time, up to 238 days, so roughly 6 months going up to 9 months. That doesn't mean that every case will wait 238 days, nor does it mean that 238 days becomes a backstop. But that is a provision which government is bringing in this month, not for existing cases, but for new cases. Meanwhile, sorry, Razia, do you want to come in on that?
No, you just answered the question. So it's not for existing cases, it's for new cases. So
yes, I understand it, yeah.
Okay, so I'm just, because there is a question about whether you think that the CPS and the Ministry of Justice should have some idea of the number of defendants who are going to be affected by this.
Well, clearly, we know what the existing number of cases is within the system, hence the backlog calculation. Nobody can know how many cases are coming along that will be impacted by the extended custody time limit regime, which is coming in through statutory instrument later this month, as I understand. So we don't know absolutes, but it's an expression or extension of the principle of the sort of speed that cases should go. For us, because we're operational here, we simply remain under pressure to be ready as quickly as we can. And when a judge looks at a custody time limit, as many people know on this call, what he or she does is look at whether there's a good and sufficient cause, that's the legal test, to extend custody time pending trial. But, and this is the one I emphasize, a judge in every case also looks at diligence and expedition on the part of the prosecutor. So there's no way around it. Whatever the statutory limit may be, we always, and in every case, have to show due diligence and expedition. We literally have to compile a chronology of the things that we have done to prepare the case, so that we're able to say, if this case can't be reached within the ordinary limit and we need to apply for an extension, that is not because of any fault on our part. Where it's our fault, then you wouldn't expect the extension to be granted. So it's our job to make sure we're not at fault. I can't be responsible for other aspects of the system, and I can't be responsible for the court estate and how many physical courts there are. That's for the Ministry of Justice and the Lord Chancellor.
You were talking, Max, about the shortage of prosecutors. This is a question from Ibrahim Ilyas. What advice would you give to aspiring prosecutors?
Well, since we were given, and I repeat my gratitude, some additional money last year, we've set about reversing the decline in our numbers. And what that means in numbers is that we have a national recruitment campaign for 390 more Crown prosecutors and actually another 100 administrative staff. So I guess the answer to Ibrahim is there are opportunities. There are opportunities at the Crown Prosecution Service. I was speaking to you as someone who practiced as a barrister, self-employed for 30 years. I'm not saying that anybody who wishes to prosecute in court should immediately and only contemplate a career at the Crown Prosecution Service. The way our system works so well is because we have that mixed economy, to coin a phrase, between full-time staff who are contracted to the Crown Prosecution Service, and then thousands of external barristers and some solicitors who appear in court for us. And the crossover between the two is really valuable. So if you want to become a prosecutor, there remains more than one way of doing it. You can go to the bar, and like me, you can prosecute from time to time, which I did for 30 years, or you can come to the CPS. What I would say, without in any sense bearing down on the external bar, and I hope I've made it clear how faithful I am to them, what I would say is that we have some great opportunities here for legal trainees, for apprentices, and for fully qualified lawyers to come to the CPS. And if that is your choice, what you will find is that you have the entire breadth of criminal justice at your disposal. Obviously, we only deal with crime, but there are very disparate and varying careers to be had here. And if you conduct your trainee year here, you'll see lots of that, and that will inform your choice on the sort of prosecutor that you want to be. And so obviously I encourage anyone who's interested in the CPS to come and join the thousands of excellent lawyers and prosecutors that we already have.
Thank you very much, Max. I'm going to be cheeky and end with a question from me. So when you became DPP in November 2018, obviously you had an in-tray that was full of challenges. That tray is even more bulging now in the context of the pandemic. I wonder what regrets you have, or how much you've aged in that time, and how you have found being the Director of Public Prosecutions.
It's a huge privilege. Some people might say it's cheesy to say that, but it is a massive privilege to hold this position. I'm extremely lucky to hold it. There've only been 8 DPPs since the start of the CPS, and to be amongst that number is a massive privilege. I do not have any regrets. It is a busy time. The in-tray, which I'm looking at, Razia, off screen, is huge. But you know, the job wouldn't be worth it if everything was easy, would it? You want to face challenge. I didn't envisage that we'd have a challenge such as all of us have in 2020, but challenge makes the best of you. And so I think that the words I end on are never mind what I'm doing. What makes this so worthwhile is the fantastic work that everybody else in the CPS is doing, and that's what gets me out of bed every day.
Max Hill, QC, Director of Public Prosecutions, thank you so much for joining us in this conversation. Thank you to everyone who has been watching, listening, and to all those who put questions forward too. And my thanks to everyone who has been involved with this. Max Hill, thank you very much indeed. Thanks.
Thank you very much, Razia.